So in this case, Your Honor, where my clients had no non-compete agreement, they were free to go to work for XYZ company. There was only a confidentiality agreement and an agreement not to call on customers of ABC. And there's no evidence that my clients have called on any customers of ABC since going to work for XYZ. So there was no reason, there's no evidence that the individual defendants here had contacted an attorney, had had any discussions with XYZ about the possibility of litigation, or had been threatened with litigation. So the idea of a duty to preserve at the time that the sea cleaner was run is a stretch. And without a duty to preserve, there's no basis for sanctions at all for sea cleaner, Your Honor. Now, with respect to the flash drives, I will concede, Your Honor, and the defendants freely admit that it was poor judgment on their part to have discarded those flash drives. My clients, the individual defendants in this case, and XYZ too, have suffered greatly for that. The sole thing perpetuating this litigation for the past year has been that mistake. Apart from that mistake, there's no evidence at all for the plaintiff to hang their hat on to continue this litigation. And Your Honor may be aware that the defendants actually have a pending motion for summary judgment based on the plaintiff's failure to come forward with any evidence at all to support their claims. So, Your Honor asked about sanctions. And I understand why, Your Honor, with respect to the flash drives that were discarded after the commencement of the litigation, which again goes only to Mr. Smith and not Mr. Brown. But after the commencement of the litigation, Your Honor might reasonably question whether that disposal imposed any costs, any extra costs on the plaintiff in this case. And Your Honor, I think we have a very strong argument that no additional costs were imposed. It is certainly routine in a case where a misappropriation of confidential information is alleged or theft of trade secrets is alleged, and that's the core of what this case is about. It's almost universal practice now to have a forensic expert come in and examine the laptop computer of the individual defendant, both the one that he used at his old company and the one that he's using at his new company. And that's exactly what happened here. Now, if the plaintiff had gone to the trouble to try to single out some specific item of inquiry by its forensic expert that was made necessary by not having access to the flash drives, then frankly, Your Honor, we wouldn't be here having this oral argument right now. But that's something that we could have reached a resolution on. But that's not what the plaintiff is doing here. The plaintiff is swinging for the fences by asking for all of its legal fees and all of its forensics fees.
Opposing counsel has made an eloquent argument on the wrong issue. The issue is the destruction of evidence, not what will ultimately happen in the jury trial, not what will happen when the parties are arguing loss of customers or whatever else. This motion is about the deliberate and intentional destruction of evidence. And let me again quote from the Illinois courts. Discovery for all parties will not be effective unless trial courts do not countenance violations and unhesitatingly impose sanctions proportionate to the circumstances. We're talking about an intentional course of conduct that destroyed evidence. We're not talking about what the ultimate issues will be before a jury.